Melbourne Law School. Okay. Ya, juga saya mengucapkan terima kasih atas kehadiran semuanya peserta webinar kali ini ya, yang bersedia hadir pada kesempatan ini. Ini merupakan suatu momen yang sangat bagus buat kita semua bisa hadir pada kesempatan ini. And maybe I think Prof. Lindsey juga merupakan seorang pakar dalam bidang Indonesian law ya. Nah, mungkin bagi kita bisa kita menarik suatu pelajaran mungkin bagi kita semua pelajaran mungkin yang kita tarik bagaimana kita bisa seperti beliau gitu ya, bisa mempelajari hukum Indonesia gitu mungkin. Dan juga mungkin terima kasih juga kepada Pak Chandra yang sudah mempersiapkan semua acara ini dengan baik ya, dengan baik semuanya dan bisa terorganisir dengan baik, dan hopefully this webinar bisa nanti menjadi suatu hal yang bisa menginisiasi kita kembali untuk melakukan kolaborasi dalam hal yang lainnya, seperti misalnya tidak saja dalam kegiatan webinar, tapi mungkin bisa joint collaboration dengan melibatkan aktivitas mahasiswa, mungkin dengan research ataupun nanti dalam teaching ya, dalam learning about this nanti semua nanti bisa kita buat bersama, dan kami dari Pasca nanti pastinya akan mendukung semua hal tersebut. Dan sekali lagi I would like to thanks Prof. Lindsey for your for your cooperation for this webinar, dan terima kasih juga untuk semua yang hadir pada kesempatan ini, dan saya mengucapkan alhamdulillah dan assalamualaikum warahmatullahi wabarakatuh. Terima kasih. Saya kembalikan ke moderator.
Terima kasih Ibu Maya. Kemudian selanjutnya kami langsung kepada Pak Chandra saja. Kepada Pak Chandra kami persilakan.
Ya, terima kasih. Baik, Ibu Maya, terima kasih atas welcoming speech-nya. Saya akan coba membahas mengenai materi yang cukup rumit ini sebenarnya ya. Ini rumit karena translation itu kan untuk untuk yang menguasai bahasa benar ya. Tapi sebelumnya saya mohon izin sebentar saja. Saya mau ngirim email ke tim Lindsey ya, sebentar saja ya. Kita mulai ya. Sebenarnya sangat dibutuhkan baik bagi lawyer maupun bagi notaris sebenarnya, di mana materi bilingual dibutuhkan ya, sangat dibutuhkan di dalam sebagai dokumen yang nanti akan dibuktikan di pengadilan, karena yang namanya kontrak itu sebagai alat bukti nantinya ya, di pengadilan akan sebagai alat bukti, tetapi secara personal atau pribadi itu dijadikan ikatan dari para pihak dengan itikat baik ya, dengan itikat baik yang pasal 1338 kita sudah kenal, yaitu semua persetujuan yang dibuat secara sah menjadi undang-undang bagi mereka yang membuatnya. kemudian tidak bisa dicabut secara sepihak, dan yang terakhir dengan etikat baik. Nah, ini 3 konsep ini sebenarnya merupakan merupakan bagian-bagian dari yang namanya fakta sunt servanda. Ya, nah, dalam hal ini saya akan bahas lebih jauh mengenai translation-nya seperti apa sih yang dibutuhkan. Ya, nanti mungkin tim Lindsey akan membahas lebih lanjut ya. Bentar, saya share dulu ya. Nah, saya mulai dengan bilingual contract drafting. Di sini sebenarnya saya nggak bicarakan kontrak drafting, tapi saya membicarakan bilingualnya. Ini tidak mendalam mengenai kontrak draftingnya. Kalau nanti memang berminat, nanti kita bisa mengadakan kontrak drafting dengan dalam bahasa Inggris yang lebih dalam ya, lebih intensif, di mana mungkin trainingnya 2 hari 3 hari seperti yang dulu saya pernah lakukan. Tapi legal language ya, legal English, kita belajar legal English. Nah, saya mulai dengan 1 sama dengan 1 ya. Kalau kita menggunakan 1 code 1, masalahnya tidak akan ada masalah ya. 1 kita bisa tahu dengan sendirinya. Kalau dengan numerical nggak akan ada masalah, terjemahan apapun akan sama dengan 1 juga. Kita mau pilih yang manapun juga akan sama ya, kalau angkanya numerical. Kalau yang kita bicarakan numerical, tapi kalau yang kita bicarakan adalah abjad, ini akan mengandung suatu persepsi. Nah, persepsi ini yang bisa beda-beda ya, karena pengalamannya dan sebagainya nanti saya akan jelaskan ya. Struktur bahasanya itu akan mempengaruhi juga di dalam kita menerjemahkan. Tapi sebelumnya kita mesti tahu dulu ya. Jadi di sini 1 sama dengan 1. Kalau kita bicarakan numerikalnya nggak ada masalah, udah sama dengan mau dari kiri atau kanan nggak ada masalah. Ya, tetapi kalau terjemahannya 1 dengan 1 itu sama. Kalau kita pakai konsep yang general merujuk kepada 1 angka ini dan 1 angka ini. Ya. Kita mulai dengan Undang-Undang Nomor 24 tahun 2009 yang mengatakan bahwa bendera, bahasa, lambang, dan lagu kebangsaan pasal 31 bahasa Indonesia wajib digunakan dalam nota kesepahaman atau perjanjian yang melibatkan lembaga negara, instansi pemerintah Republik Indonesia, lembaga swasta Indonesia, atau perseorangan warga negara Indonesia. Jadi kita melihat di sini, oh ternyata kita membutuhkan bahasa Indonesia di sini, wajib dengan bahasa Indonesia untuk perseorangan warga negara Indonesia sekalipun. Ya, ini di sini kita lihat di sini adalah warga negara Indonesia. Ya, jelas perjanjian umum pun juga antara asing, ya antara orang Indonesia dengan orang asing tentunya harus dengan bahasa Indonesia. Ya, jadi ini sangat domain dalam bahasa Indonesia. Kemudian juga pasal 31 ayat 2 ya, melibatkan pihak asing, maka dalam bahasa nasional pihak asing tersebut dan atau bahasa Inggris ya. Jadi boleh bahasa PBB, tetapi kan yang paling bisa dikenal adalah bahasa Indonesia, bahasa Inggris ya. Jadi terjemahan lebih dominan ke bahasa Inggris. Ya, jadi sebenarnya kita bikin 2 kolom di sini kalau kita menerjemah membuat kontrak dengan warga negara asing. Ya. Oke, selanjutnya Peraturan Presiden Republik Indonesia Nomor 63 Tahun 2019 tentang penggunaan. Ini juga dalam peraturan pelaksananya ya yang dibuat tahun 2009 ya. Pak Jokowi presiden kita juga sudah mengeluarkan ini ya, juga dia mengadopsi dari undang-undang bahasa tadi ya, undang-undang bendera tadi pasal 26 ayat 1 Ya, bahasa Indonesia wajib digunakan dalam nota kesepahaman, perjanjian yang melibatkan lembaga negara, instansi pemerintah, dan seterusnya ya, atau perseorangan. Jadi sama persis ya dengan undang-undang bendera. Nah, ini juga disebutkan bahwa nasional pihak asing. Ya. Hanya dia ditambahkan lagi di dalam peraturan pemerintah ini bahwa bahasa Indonesia pihak asing dan atau bahasa Inggris sebagai dimaksud pada ayat 2 digunakan sebagai padanan atau terjemahan bahasa Indonesia untuk menyamakan pemahaman nota kesepahaman perjanjian dengan pihak asing. Jadi ditekankan di sini bahasa Indonesia atau bahasa asing. Nah, bahasa Inggris. Bahasa asing ini bahasa PBB yang dimaksudkan ya. Nah, tetapi orang lebih di penekanannya di sinilah adalah bahasa Inggris ya. Sebagai padanan, terjemahan. Ya, terjemahan jadi berdampingan ya. Bukan bagian dari bahasa itu tetapi adalah berdampingan. Ya. Yang keempat yaitu nanti kalau seumpamanya terjadi perbedaan penafsiran antara bahasa Indonesia dan bahasa Inggris atau bahasa lainnya, maka yang akan digunakan adalah bahasa yang disepakati. Kalau supaya disepakati bahasa Inggris, maka bahasa Inggris yang akan digunakan sebagai tafsirnya. Ya. Tetapi tetap harus ada terjemahan dalam bahasa Indonesia. Ya, jadi terbalik dengan artinya ada kepanjangan dari yang namanya bahasa di dalam undang-undang bahasa tadi ya. Kalau undang-undang bahasa harus bahasa Indonesia di sini atau bahasa asing lainnya boleh tetapi tetap bahasa Indonesia yang akan digunakan. Kalau di sini kan lebih menekankan kesepakatan dari bahasa tersebut tetapi harus tetap ada dalam bahasa Indonesia sebagai terjemahannya. Ya, walaupun itu yang disepakati dalam bahasa Inggrisnya. Nah, padanan terjemahan tidak memiliki permasalahan. Nah, permasalahannya struktur bahasanya. Ya, struktur bahasa, perbedaan budaya, compound word, verb up to word. Nah, ini hal-hal yang membedakan antara bahasa di dunia ya. Ada ada word yang memiliki beberapa pengertian, kayak kita mungkin bisa adalah bisa ular, bisa adalah bisa dapat ya, seperti itu. Kemudian apa sih yang sebenarnya kan bahasa itu abjad yang disusun untuk membentuk suatu fonetik ya, suara yang bisa membedakan dengan kata lainnya ya. Sebenarnya yang kita gunakan kan abjad yang sama, alfabetik yang sama, A B C D E sampai Z ya. Bahasa Inggris juga A B C D E sampai Z. Tetapi kata-kata yang disusun akan mengeluarkan fonetik yang berbeda sehingga mempunyai persepsi yang berbeda. Misalnya membeli, saya membeli kemudian buy, membeli juga ya. Dalam persepsi saya membeli sesuatu ya. Ini bisa dipersepsikan atau disandingkan tadi ya, sebagai sandingannya ya, antara membeli dengan buy ya. Itu bisa dipersandingkan. Nah, ini yang dimaksudkan dengan terjemahan tadi ya. Tetapi kembali lagi, person perception refer to the ability to identify new social cues about people and relationship. Jadi persepsi person itu harus bisa membedakan ya, mengidentifikasi bagaimana ini digunakan di dalam sosialnya ya, dalam masyarakatnya ya, hubungan dengan masyarakat. Sehingga kalau kita ngomongin merchandise misalnya, di dalam kita lagi berkomunikasi dengan orang Indonesia, mungkin kita nggak masuk dalam wilayah yang tadi itu, ya. Dia tidak bisa mengidentifikasi misalnya kalau dia tidak bisa bahasa Inggris, tidak mengerti konsep merchandise tersebut. Ya. Nah, di sini ada person perception yang harus sama dengan satu sama dengan satu, sehingga kita bisa ketemu benda yang sama. Ya, benda yang sama ini bisa ketemu, gitu ya. Kemudian ada social perception juga yang tadi saya bilang stereotype dan sebagainya ya. Ini juga apa namanya, juga masuk ke dalam wilayah pengertian yang bisa menjadi persepsi kita. Ya. Misalnya kita ngomongin Melayu ataupun orang hitam dan sebagainya, itu udah masuk ke stereotype. Kemudian apa namanya, environmental juga demikian. Ya. Jadi yang namanya stimulus dalam lingkungannya, environment-nya juga memiliki akan membentuk suatu persepsi yang berbeda dengan kita. Ya. Konsep pun juga demikian ya. The attended stimulus is the specific object in the environment on which attention is focused. Kemudian juga image on the retina juga. Kalau kita melihat sesuatu, kemudian kita membuat suatu code ke dalam kata kita, ya, maka pada saat kita melihat bentuk yang sama, maka retina kita akan bisa melihat bentuk yang sama, maka kita mempunyai konsep persepsi yang sama. Ya, saya membicarakan misalnya rumah. Kalau saya tinggal di rumah Minang misalnya yang bertanduk, dan saya tidak memiliki pemikiran-pemikiran lain, ya, atau persepsi-persepsi lain, maka apa yang saya lihat begitu ketemu teman yang dari Jawa misalnya, dia punya rumah joglo, saya ngomongin rumah, persepsi saya adalah rumah yang ada, rumah yang saya lihat selama ini, yaitu bertanduk. Ya, sementara teman saya dari Jawa menganggapnya rumah joglo, gitu ya. Kalau kita ngomongin rumah. Nah, ini kan persepsi retinanya. Tetapi kalau kita ngomongin sesuatu yang sifatnya umum dan bisa meeting of mind-nya ketemu di sini, maka kita bisa mengatakan bahwa ini sesuatu hal yang sama dengan ya. Kemudian transduction, the image on the creator transform into electric signal. Ya, kemudian juga natural processing juga termasuk yang membentuk persepsi. Ya, ada suara yang sifatnya adalah 5 panca indera kita. Ya, pada saat kita bicarakan misalnya hollow packer dalam komputer kita dengan model sekian-sekian, maka kalau kita yang kita tahu, ya, dengan persepsi yang ada, kita sudah mengetahui gambarnya dan sebagainya, kita sudah bisa menyebut kata tersebut, kita langsung sudah dapat persepsinya. Ya, karena apa? Karena kita sudah mengalami dengan panca indera kita. Ya, sesuatu yang kita raba, kita lihat dan kita dengar, ya, itu akan membentuk dari persepsi. Nah, ini termasuk recognition. Perception doesn't just involve becoming consciously aware of the stimuli. It's also necessary for the brain to categorize and interpret what you are sensing. The ability to interpret and give meaning to the object is the next step known as recognition. Ya. Nah, ini juga action juga demikian ya. Ringkasnya action juga demikian. Nah, kemudian nah, ini kan persepsi-persepsi yang kita terima dalam bahasa-bahasa yang kita kenal, ya, yang kita sepakati di dalam masyarakat, di dalam populasinya, di dalam masyarakatnya kita tahu, ya. Saya merasakan, misal merasakan garam, merasakan sambal, ya, kita ngajak makan, kayak saya ngajak makan orang asing, saya makan di restoran Padang. Saya tahu, saya sengaja bawa yang pedes gitu ya, yang pedes, saya ajak makan yang pedes, dia biar ngerasain, oh dia kepedesan gitu kan. Kenapa? Karena taste itu, ya. Nah, demikian juga yang namanya pengalaman ya, pengalaman itu akan membentuk persepsi. Nah, ini kan akan mengalami kesulitan, lebih-lebih kita melihat di sini ya, bahwa yang namanya bahasa Inggris itu dia sudah bercampur baur dengan bahasa-bahasa lainnya. Ya, saya kasih. Nah, kalau kita lihat Inggris ini bahasanya adalah dari mulai Roman, zaman Romawi dulu, kemudian dia local inhabitants speak Celtic, ya, seperti kemudian masuk ke zaman Romawi, kemudian menarik diri dari Inggris, ya, kemudian masuk Jerman, ya, nama pada saat itu Jerman, kemudian pada saat itu kita mengenal setelah dijajah Jerman, kita mengenal Old English, ya. Old English misalnya contohnya are, is, or, ya, atau by, with, dan sebagainya. Mereka bahasa yang sangat sederhana, ya, pada saat itu masih inilah, ya. Tapi kemudian dia berkembang lagi. Sama juga kayak kita kan, dia pakai bahasa-bahasa yang digunakan. Cuman kalau kita kan beda, ya, bahasanya langsung bahasa Indonesia, ya. Kalau mereka bahasa-bahasa jajahan, mereka masuk di sana. Sehingga kata-katanya jadi berlipat-lipat, jadi banyak, yang bertambah banyak, sehingga pada akhirnya nanti mereka membuat suatu yang namanya legal English atau bahasa kedokteran juga dan lain-lain. Jadi spesifik kepada bahasa yang profesinya, ya. Nah, ini kita kenal sebagai legal English di sini. Nah, dari perkembangan ini, misalnya dari Middle English, kemudian English replaced Latin as the language of instruction in most school, ya, mereka juga menggunakan Latin, ya, bahasa-bahasa yang lebih kompleks daripada Old English, ya. Kemudian English replaced French, bahasa Prancis juga, kayak merchandise misalnya, kita kenal sebagai bahasa Inggris, tapi itu asalnya dari bahasa Prancis, ya. Kemudian masuk social start with writing dengan teori novel-novelnya Shakespeare dan sebagainya, muncul itu, ya, bahasa-bahasa yang lebih kompleks dari bahasa yang ada. Kalau kita dengar orang Amerika ngomong sama orang Inggris, bahasanya lebih mendayu-dayu bahasa Inggris dari mereka, ya, dari London gitu, ya. Dari Australia pun juga berbeda, ya. Nah, kemudian masuk juga Shakespeare meninggal, kemudian muncullah bahasa-bahasa lainnya, ya. Nah, seperti Thomas Jefferson, kemudian Amerika membuat, kan mereka merdeka, kemudian mereka bikin bahasanya sendiri, ya. Terbentuknya bukan bahasa sendiri, tapi memang terbentuk karena masyarakat di sana, ya. Kemudian juga mereka mengeluarkan yang namanya dictionary, kemudian Broadcasting Corporation is founded, ya. Kemudian Oxford English Dictionary tahun 28 dipublish, ya. Nah, ini semua membentuk bahasa Inggris yang sangat kompleks, ya. Tidak sesederhana bahasa Indonesia, karena mereka udah campuran dari bahasa Indonesia yang sudah nggak semua orang bisa mempelajari, ya. Bukan semua orang, maksudnya semua warga negara Indonesia dengan sendirinya nggak terlalu sulit, ya. Nggak seperti bahasa Inggris. Mereka pun, walaupun orang Inggris, belum tentu mereka bisa kalau mereka nggak belajar tentang legal language, ya. Kalau kita kan bahasa kontrak, ya bahasa Indonesia yang kita pakai sehari-hari, ya. Nah, ini bahasa tadi, gimana kita mau mentranslate, sementara kontrak itu dalam bahasa legal language. Legal language ini sangat kompleks karena mereka double-double. Misalnya, null and void, ya. Kita terjemahkan dalam bahasa Indonesianya, nggak ada null and void, akhirnya batal demi hukum, gitu, ya. Konsep itu terbentuk dalam sistem hukum kita sendiri dengan bahasa kita, ya. Sebenarnya batal demi hukum itu bukan berasal dari konsep orang Indonesia, tetapi itu konsep dari Belanda, ya. Belanda yang kemudian diterapin ke Indonesia, lalu kita mencari bahasanya. Nah, tetapi kalau di Inggris sudah ada sebenarnya null and void. Null itu bahasa yang berbeda, asal kata yang berbeda. Jadi yang namanya legal language itu mengambil term word-word yang memang asing buat mereka sendiri. Ya, jadi bukan bahasa yang biasa, bahasa Inggris biasa, tetapi mereka ngambil yang paling mempunyai kekuatan, ya, karena dia kan bermain dengan retorikal di sini. Jadi dia ambil bahasa yang sangat apa namanya rumit, kompleks. Ini yang kita sebut sebagai performing specifically related purposes. Ya. Kemudian yang namanya hukum kan bukan masalah bahasa. Ya. Kalau kita mungkin bahasa, karena kita sistemnya ada dengan sistem hukum kita bergantung sekali kepada kata di dalam code. Beda dengan mereka yang common law system yang sifatnya apa namanya konkret, sifatnya konkret, di mana nanti peristiwa yang terjadi disesuaikan dengan hukumnya melalui keputusan hakim membuat hukum. Judgment law kita nggak membuat hukum, ya, kita nggak mengenal presiden. Kalau mereka mengenal presiden, makanya mereka di dalam statuto law-nya juga terdapat putusan-putusan pengadilan yang membentuk juga dari hukum tersebut. Ya, ada nilai-nilai dan norma-norma yang hidup. Nah, kalau kita kan nilai norma hidupnya di dalam hukum adat, ya. Kalau mereka nggak dimasukkan ke dalam sistem hukum mereka. Nah, kemudian, nah, formation kontrak mereka kan juga, kalau kita andalannya adalah 1233, sumber hukum dari persetujuan dan undang-undang. Kemudian 1313 itu dari semua persetujuan, ya, mengikatkan diri, sumbernya adalah perjanjian, fakta unsur panda, semua perjanjian 1338, ya, semua persetujuan itu masuk ke kontrak, kebebasan berkontrak yang masuk di wilayah situ, ya. Jadi sumbernya adalah di 1338, ya, fakta unsur panda tadi. Benar yang masuk, yang hidup dalam masyarakat, tetapi dikodekan, dituangkan di dalam 1338, ya. Kalau sistem common law kan enggak, mereka bebas ada di luar yang kemudian di-accept oleh hakim untuk menjadi suatu keputusan, baik itu sifatnya teori maupun filsafat dan lain-lain, ya. Nah, itu dimasukkan ke dalam situasi konkret yang ada, yang kekurangan hukum, yang kosong hukumnya dimasukkan ke sana. Nah, contohnya gini, formation of contract di sini, ya. Formation of contract ada over acceptance, consideration, contractual intention, dan form. Mereka mengandalkan kata sepakat, kemudian tanda tangan di dalam kontrak. Kalau mereka over and acceptance, kalau tanggal pun berbeda, tanggal kontraknya tanda tangannya berbeda, nggak ada masalah. Mungkin pas kuliah saya udah jelaskan, misalnya dalam promosi, ya, ada intention to legal relation, kemudian ada juga masuk pada saat kita meng-offer di promosi di misalnya buah-buahan, ya, apel Malang yang saya kirim, yang saya tawarkan di promo JCC, misal ada internasional buah-buahan, ya. Nah, saya tawar di situ, kemudian mereka orang asing datang, kemudian mereka tertarik dengan itu, kemudian dia masuk ke dalam kontrak, ya, kontrak, tanda tangan, kemudian dieksporlah ke tempatnya. Nah, pada saat diekspor itu harus sama dengan antara buah yang ada di dalam yang dipromokan dengan yang ada di dikirim di pelabuhannya, ya. Kenapa? Karena pada saat itu kalau kita kan ngandalnya kontrak, kalau udah yang namanya apel Malang, nggak ada lagi apel di dunia ini selain adanya di Malang, ya, apel Malang itu, gitu, ya, apel Malang yang dimaksud apel Malang tersebut, ya. Nah, jadi kita mengandalkan bahasa, kita akan bergantung kepada bahasa sebagai dasarnya. Beda dengan mereka konkretnya, ya, kemudian mereka ambil kalau sumpamanya belum diatur, mereka ambil melalui suatu putusan presiden. Ya, nah mereka berkembang nih. Nah, kemudian kita mau terjemahkan ke dalam bahasa Indonesia ini kan akan sangat sulit karena konsepnya akan sangat berbeda ya. Nah, offer sebagai pengusaha pemalang tadi ya, bagi pembeli, kemudian acceptance sepakat dituangkan dalam kontrak, consideration apa yang dipromosikan Apple. Ya. Nah, ini di mana consideration-nya ya apel Malang. Apel Malang yang mana? Yang ada di dalam kontrak atau yang ada di dalam promosi. Ya, yang konkretnya atau yang ada di dalam abstraknya. Nah, kalau abstrak kan mengenai bahasa. Kalau bahasa yang tadi saya bilang, kan kita punya pengalaman yang nggak harus diulang di dalam bahasa. Kalau kita ngomongin yang namanya, saya bicarakan Hewlett Packard misalnya, Hewlett Packard komputer dengan ini kita dengan persepsi yang sudah kita tanam tadi dengan panca indera kita kan nggak harus ulang mengalami lagi. Dengan bahasa itu abstrak itu sudah merujuk ke situ. Ya, dengan pengalaman kita udah merujuk. Jadi kita sepakat dalam bahasa. Tetapi kalau ada perbedaan konkretnya, ya, perbedaan konkret dari apel tersebut, itu nggak akan bisa dicakup di dalam sistem hukum kita. Nah, ini yang bermasalah. Ya, kita ngomongin null and void, mereka ngomongin batal demi hukum, kemudian kita ngomongin dapat dibatalkan. Mereka ngenanya null and void ya udah untuk keseluruhan. Ya, kalau untuk common law tertentu ya. Mereka anggap seperti itu. Nah, kemudian mereka menggunakan legal English to plain English. Ya, sekarang sih mereka sudah mulai mencoba menggunakan bahasa Inggris yang umum saja, karena terlalu kompleks legal English ini. Tetapi dalam kenyataannya masih aja orang menggunakan legal English di dalam kontrak law-nya. Hukum kontraknya ya. Mereka menggunakan itu sehingga dalam menjadikan kita nggak bisa dengan bahasa umum, sementara bahasa Indonesia adalah bahasa umum ya, tidak spesifik seperti mereka yang lebih banyak kata-katanya ya yang tuang di situ. Kemudian hukum adalah disiplin yang membutuhkan ungkapan yang tepat. Nah, sementara yang namanya hukum kan kita bermain dengan rhetorical, berdebat, berargumentasi di pengadilan, kita akan mendalilkan hal-hal yang nanti akan dibuktikan, ya, tentu dengan bahasa yang tepat antara konkretnya dengan yang terjadi dengan abstraknya, ya. Nah, tentunya bahasa itu harus merujuk ke sana. Nah, kalau kita berbicara mengenai yang namanya terjemahan, tentunya terjemahannya juga harus merujuk hal yang sama. Tadi kalau kita bicarakan mengenai terjemah apel Malang, ya, kalau kita memakai bahasa kontrak, artinya yang dikontrakkan, belum tentu merujuk yang rasanya sama dengan yang dipromosi, ya, di pameran apel buah-buahan internasional tersebut. Karena kalau kita ngomongin apel di dalam konkretnya, ya kan yang dirasakan yang ada pada saat kita membeli apel tersebut, merasakan waktu saat kita ada promo tersebut, dan kita rasakan itu kalau kita belum pernah sebelumnya. Dan bukan kepada bahasanya, ya, tapi rasanya. Makanya saya mau consider, ya, consider dalam arti tadi ada unsur consideration-nya, enter into the contract, karena ada barang yang saya udah pengalaman yang sudah saya alami tadi sebelumnya, ada offering, ada tawaran dari saya kepada orang asing tersebut, gitu ya. Nah, kalau kita kan enggak, kita adalah mulai kontrak itu, offering itu nggak dipertimbangkan lagi, tetapi kontrak itu sudah merujuk, dianggap sudah merujuk karena pengalamannya. Ya, meeting of mind-nya sudah ketemu di dalam bahasa. Ya, meeting of mind atau persepsinya sudah sama dianggap. Ya. Kemudian juga terjemahan sembarang dapat mengubah makna sepenuhnya untuk menghindari hal ini. Nah, gunakan terjemahan yang tadi saya bilang. jangan kalau bisa, kalau kita mau terjemahkannya, terjemahkan dulu ke dalam bahasa Inggris yang lebih bisa digunakan. Tadi yang saya bilang satu dengan huruf satu, one, satu dengan huruf one. Nah, itu lebih numerikalnya lebih bisa diterima tanpa ada bias-biasnya ya. Nah, ini kan lebih pakai bahasa yang lebih umum. Kenapa yang lebih umum? Karena nggak spesifik, jadi lebih bisa memiliki irisan yang hampir sama ya dengan yang umumnya. Gitu. Nah, di sini perancang kotak perlu untuk mengklarifikasi, mengadakan versi bahasa Inggris ya. Nah, sebuah solusinya itu Indonesia batal demi hukum tadi yang saya jelaskan. Nah, misalnya Inggris umum, kalau bahasa umumnya refuse, reject, ya dia punya transitif, intransitif, dia memerlukan objek atau tidak ya. Nah, ini kan bisa kita pelajari ya. Kalau bahasa Inggris null and void, dia udah langsung merujuk kepada konsepnya. Kalau konsep dari null and void itu pun agak beda dengan batal demi hukum ya. Nah, kalau umpamanya kita merujuk sandingannya adalah hukum mereka, karena bahasa Inggris itu adalah bahasa common law, ya bahasa common law, dan sementara kita bahasanya lebih kepada civil law, ya civil law dalam arti juga bukan bahasa Belanda atau bahasa Prancis, tetapi bahasa Indonesia ya, yang sifatnya lebih umum. Makanya kalau ada istilah yang lebih spesifik kita pakai bahasa Belanda, ya. Oke. Kehati-hatian dalam penggunaan angka dan jumlah. Ya. Menunjukkan persyaratan kewajiban oleh satu itu semua pihak. Bentar ya. Oke. Kemudian misalnya dari sini ya, obligated seperti dalam parti SE obligates ya, obligates to do XYZ. Ya, arti kan di dalam perikatan itu kan kita berbuat sesuatu, tidak berbuat sesuatu. Nah, dalam hal ini pihak yang si A dia berkewajiban ya, berkewajiban dalam arti dia punya kewajiban, karena di dalam kontrak itu ada hak dan kewajiban ya, ada hak dan kewajiban yang dituangkan di dalam kontrak. Nah, kalau seumpamanya kita menggunakan obligates atau obligate ya, nah itu tetapi kemudian akan lebih memaksa kalau digunakan misalnya shall ya. Nah, tapi kata yang kita gunakan untuk shall apa? Kan nggak ada ya. Shall itu apa? Shall seharusnya atau seharus ya, bisa juga harus, tetapi berbeda dengan kewajiban ya. Seperti itu. Nah, kembali lagi ke one. Tadi saya balik satu sama dengan satu, one sama dengan satu. Ya, one, satu, atau dibalik di awal tadi satu sama dengan one, ya sama pengertiannya. Tapi yang kita gunakan adalah bahasa yang sama, merujuk kepada numerical, bukan kepada kebudayaan, bukan kepada konsep-konsep. Ya, nah dalam hal ini ada permasalahan selain dari masalah-masalah nanti akan diangkat oleh Prof. Lindsey tentang case law-nya. Ya, terima kasih. Ya, saya rasa cukup saya ya.
Baik, Pak Chandra, terima kasih banyak atas penyampaiannya. Kemudian selanjutnya
Prof.
kami persilakan kepada Prof. Chandra untuk menyampaikan
Prof. Tim,
materi berikutnya.
bukan Prof. Chandra, Prof. Tim.
Baik, Pak. Prof.
Tim Lindsey.
Baik, Pak. Dipersilakan.
Halo, Prof.
Halo Prof, halo tim Lindsey. Halo,
Udah masuk belum, Prof, timnya?
halo tim Lindsey.
Tunggu dulu, mungkin dia lagi ini ya.
Baik Pak, barangkali ditunggu dulu ya Pak.
Oke. Ini mungkin masih jam 9.42 ya. Jam berapa sekarang ya?
Jam 9.57 Bapak.
Oke. Kita tunggu. Oh ya, oke. Hai, Prof. Prof Tim,
Halo tim,
the mic is off. The mic is off.
halo tim, you can open your mic.
Selamat siang. Thank you very much.
Selamat siang.
Selamat siang.
How are you?
Very well, thank you. Very well. Happy to be here,
Yeah, okay.
even if
Yeah,
only remotely.
now in Jakarta it's a rainy day. It's rainy all the time.
Well, it's very hot here. It's
Yeah.
I'm just checking what the temperature is.
Okay.
It's extremely hot. It's 35. It was 40 yesterday.
Oh, okay.
You probably remember, Prof. Chandra.
Yeah, I'm one of your students.
Yes, that's right.
Yeah, okay. Apa namanya? Okay, maybe moderator,
Ya,
ya dipersilahkan loh.
oh ya, Profesor Tim, you may menyampaikan speech untuk hari ini, pemaparan materinya. Kami silakan kepada Profesor. Thank you.
Bisa dimunculkan nggak itunya? Apa namanya PPT-nya ya?
Okay. Excuse me. So, should we start?
Yeah, yeah, you can start.
Okay. Shall I begin?
Yeah,
Okay, I'll just
it's your
try
turn now.
Okay, thank you very much. I will just try to share my screen. Just 1 minute. Okay, I think, can you see my PowerPoint?
It's blank.
We cannot see Profesor.
Sorry, just
Right.
1 minute. No, I think I can share it here.
Okay.
Yeah, okay.
Okay, so we can see.
Thank you very
the
much.
presentation. Thank you.
Okay, thank you very much. It's a great pleasure to be here. And I'm very grateful to my Mantan Mahasiswa, Prof. Chandra, for the invitation.
Yeah, thank you,
it
Prof,
is good.
for your time.
It is good to be speaking from Australia to Indonesia, although it would be better to be in Indonesia, I think, at the moment. And I hope to see you all soon, face to face.
Yeah,
Okay.
yeah. Be glad.
Today I want to talk to you Indonesian language requirements, business and the validity of contracts. Careful and precise drafting is essential for a contract to be effective. The wording of a document has to reflect contractual negotiations and the intentions of the parties as exactly as possible. And one of the most important aspects of this, of course, is the choice of language and how you use it. If language is not clear, if it's not precise, problems follow. And where the parties, the pihak in a contract, have poor understanding of each other's languages, a drafting takes place in translation, or versions are created in different languages, these problems become more serious. This is a big challenge in international business. Indonesia faces this problem too. Article 31 of Law 24 of 2009 on the flag, language and state emblem and national anthem has created problems about how contracts involving Indonesian should be drafted and whether versions of the contract in a language other than Indonesian have any validity. As a result, most Indonesian law firms now usually draft all contracts involving foreign parties in two languages, one of them Indonesian, but it is not clear whether this is a complete solution to the problems created by Pasal 31. So Article 31 says that the Indonesian language must, wajib, be used for memoranda of understanding or agreements that involve state institutions, agency of government of Indonesia, Indonesian private institutions or individuals of Indonesian nationality. And the same requirement also applies to electronic contracts, as is made clear by Article 48, paragraph 1 of Government Regulation 82 of 2012 on electronic systems and transactions. This says that the use of Indonesian is required for electronic contracts and other contracts intended for Indonesian citizens. But neither the law nor the government regulation say what the consequences of non-compliance are. Article 1335 of Indonesia's Civil Code does deal with that. It says, as you all know, an agreement that does not comply with the law and so lacks a permissible cause is not valid. Now, that means that a contract that is not in Indonesian language and which has as one of the parties a state institution or agency of the government, an Indonesian private institution or an Indonesian individual, will not be in compliance with the law, and so under the Civil Code, it will be invalid and unenforceable. Now, there are two other laws, instruments issued by the Indonesian government that also deal with the issues dealt with in the 2009 law. The first of these is the circular letter, Surat Edaran of the Minister of Law and Human Rights, which is intended to clarify Law 24/2009. And this states that private commercial contracts prepared in foreign languages, particularly English, will not be invalid just because they are not in Indonesian. In other words, the contract could be in English and would still be valid. It also says that parties to a contract can prepare their contracts in two languages and then can choose which version prevails if there is a dispute. Now, this was clearly an attempt to give greater clarity and certainty to foreign investors regarding the application of the 2009 Language and Symbols Law. It was clearly intended to allow them to continue to use languages other than Indonesian to record commercial agreements. And to that extent, it was in direct conflict with the 2009 law. It said a different thing to the 2009 law. So the circular letter has not been able to achieve greater clarity or certainty for foreign businesses because of the operation of the hierarchy of laws that we all know about in Article 7 of Law 12 of 2011 on the making of laws. Most Indonesian lawyers would agree that a Surat Edaran cannot override a government regulation, such as the 2012 government regulation, and certainly can't override an undang-undang produced by the DPR, such as the 2009 Language and Symbols law. So the problem here is quite simple. The Surat Edaran directly contradicts both the regulation and the law and the Civil Code. Specifically, the Surat Edaran states that private commercial contracts prepared in foreign languages, particularly English, are valid, but the 2009 Language and Symbol Laws says that a contract involving an Indonesian entity must be in Indonesian language, and the government regulation says that Indonesian language must be used for a contract intended for an Indonesian citizen. And the Civil Code says that if they don't do that, if you don't comply with the law, you're not valid. So the Surat Edaran is, to the extent of those contradictions, invalid. And so the Surat Edaran did not actually provide greater certainty for foreign investors. In fact, it created a lot of confusion. So let me now come to the second law that was introduced to try and clarify the effect of the 2009 law. And now we're looking at Peraturan Presiden 63 of 2019. By contrast to the Surat Edaran, this regulation was issued under the authority of the 2009 law, and it was issued specifically to implement the 2009 law. So it has much clearer authority and weight, and it is generally consistent with the 2009 law. It was probably a response to the problems created by the Surat Edaran. In any case, the effect of the presidential regulation is to modify the application of the 2009 law in one very important way. Article 26(1) of the presidential regulation begins by repeating Article 31(2) of the 2009 law, and then it says in Article 26(2), and this is the important part, that where there is a foreign party to the contract, a version can be prepared in English or any other language of the party, which is what the law says. And then it says, 26(3), the national language of the foreign party, or the English language, is used as an equivalent, a padanan or translation, terjemahan, of the Indonesian language to align the understanding of the agreement between the foreign and Indonesian parties. And then 26(4), it says that if there is a difference, a dispute about the wording, then the language to be used shall be the language agreed to in the agreement itself. In other words, you can use foreign languages, including English, make two versions, and you can choose which version prevails. The effect of this is that while contracts involving Indonesians must be in Indonesian, a version in another language, usually English, but it could be another one, will be prepared, has equal standing, and the parties then choose which version is relied on in a dispute. So this complies with the law and seems to give investors a choice about which version to choose. It's a useful compromise, but it will only work if contracts in two languages, dual language contracts, include a pasal, or a clause, I should say, clausal, that identifies the preferred language. So for this regulation to be effective, you must have a provision in the agreement that specifically states which language version is the dominant version, the prevailing version, the version to be used in a dispute. If the preferred language clause, which I'll call it that, the preferred language clause, is left out from a contract prepared in two versions, then the provisions of the 29 presidential regulation create a big risk. This is particularly true for foreign investors who are not fluent in Indonesian, because, of course, if the parties become involved in a dispute and there is no preferred language provision, the courts will choose the Indonesian language version. Now, this is also relevant to notarial deeds, akta authentic. The requirement that Indonesian language be used to record agreements is not limited to contracts. It goes to notarial deeds. A notarized contract, just like one that is not notarized, will be subject to Article 31 of the 2009 Language and Symbols Law, but under the Law 30 of 2004 on notaries, Article 43(1), all notarial deeds, whatever they are, contracts and other kinds of document, must be in Indonesian. Now, Article 43(1) of the Notaries Law has become problematic because many transnational transactions involving Indonesians have increased in recent years. These sorts of deals usually involve the notarizing of an English language version of the agreement between the parties. And this meant that in 2014, Article 43(3)-6 was inserted into the Notaries Law. And Article 43(3) permits deeds to be used to use a language other than Indonesian unless another law requires Indonesian to be used. This is quite a problematic provision because it contradicts 43(1), which was left there. So 43(1) says all contracts must be in Indonesian. Sorry, all notarial deeds must be in Indonesian. And 43(3) says they can be in another language unless another law says it can't. So it's extremely hard to know what this means because you now have contradictory provisions in the law on notaries. As far as I know, this contradiction has not been tested, so it remains uncertain whether a notarial deed that is only in a language other than Indonesian would be valid. That's a bigger problem when the notarial deed is not a contract, and therefore the 2009 law doesn't apply. However, if a foreign language is used, then under Article 46(3), the notary has to ensure the parties understand the meaning of that version of the deed. So the notary must either understand the other language or must use a translator to explain the foreign language version. And of course, if a dispute comes up, it may be difficult later to prove that the Indonesian party did in fact fully understand the content of the foreign language deed. In any case, Article 46(6) says that if a dispute arises about a different language version of the deed, the Indonesian version prevails in any case. So the effect of all this is that the only way that you can be certain that a notarized deed is going to be enforced by the court is if it is in Indonesian. Now, these problems have been dealt with in the Indonesian courts in a number of cases. Article 31(1) of the 2009 Languages and Symbols Law was dealt with in a landmark decision in 2013, PT Bangun Karya Pratama Lestari and 9 AM. In that case, the West Jakarta District Court decided that a loan agreement between an Indonesian company borrower and a US-based lender involving a fiduciary security was void because the contract was not executed in Indonesian. The Indonesian plaintiff argued that under the loan agreement, argued the loan agreement did not impose any liability because it was in English and there was no Indonesian language version. The court accepted this. It said that Indonesian was mandatory under Article 31(1) of the 2009 Language and Symbols Law, and so the contract was illegal under Articles 1335 and 1337 of the Civil Code. The court looked at the Surat Edaran that we've already discussed and said that, which says that contracts prepared in English will not be invalid just because they're not in Indonesian. But the court said that the Surat Edaran is not in the hierarchy of Indonesian laws, and therefore it gave no weight to the letter and set it aside. It said that all the parties are bound by the requirement of Indonesian language. And it said that if one of the parties don't like that, if they don't like the word wajib in relation to the obligation to use Indonesian language in contracts in Article 31, then they shouldn't ignore it, but to challenge that provision in the Mahkamah Konstitusi. That was not a very helpful comment by the court, because of course, foreigners are the ones who want languages, contracts in different languages, and foreigners cannot bring constitutional challenges in Indonesia. The Mahkamah Konstitusi has said that foreigners have no standing to bring a constitutional challenge. In any case, the decision of the West Jakarta District Court has been confirmed on banding by the Jakarta High Court and on kasasi by the Mahkamah Agung. And the court's position has not been changed by the issue of the 2019 presidential regulation and the option to use dual language contracts with the preferred language provision that were created by the regulation, because an Indonesian language version is still essential for the contract to be valid in the first place. Now, that was an extremely important decision, and it seems to have fixed what the law is, that an Indonesian language version is essential for validity, and the circular letter will not apply. And it seems to be the case that the presidential regulation now allows you to use dual versions, but you still need the Indonesian contract. But there have been a whole series of other cases since the Bangun Karya Pratama Lestari case. There's been at least 10 cases since 2015 that have looked at this problem. And unfortunately, those cases have made this area very unclear. The Bangun Karya Pratama Lestari case is always cited as explaining what the situation is, but the courts have not followed that decision in other decisions. They've taken different views. So what I want to do now is to try and analyze some of these cases with you, a total of 10 cases, and see what the approach is. The summary is that it's very inconsistent. And in some cases, the courts have simply ignored the 2009 language law entirely, as if it didn't even exist. So, in fact, of the 10 cases that I've mentioned, it was only in 2 of those 10 cases that the courts actually adopted the same argument as Bangun Karya Pratama Lestari and invalidated the agreement. So I'll just look at those 2 cases first. One was what I call the Kokos Jiang case, which was the Central Jakarta District Court in 2020. That was a straightforward case. The court simply applied the 2009 language and symbols law and invalidated an agreement because it was not in Indonesian. In the Gatari Air Services case, which was in 2018, the South Jakarta District Court did the same thing. But first, it rejected an argument that it had no jurisdiction because the agreement contained an arbitration clause. So I'll come back to this point, but as I'm sure you all know, Article 3 of the 1999 Arbitration and Alternative Dispute Resolution Law says quite clearly the district court does not have authority to decide a dispute between parties bound by an arbitration agreement. This creates an issue, which, as I say, I'll come back to, but I'll just flag it for now. If you have an agreement between 2 parties that is in English and not in Indonesian, and it has an arbitration provision that says the dispute is to be resolved by arbitration, it would seem that that whole agreement is invalid because it's not in Indonesian. But how can you take it to court? Because the court will say, I have no jurisdiction to consider this agreement because it's got an arbitration clause. This is a problem. It's a chicken and egg argument. Can the court consider the agreement? It's not in Indonesian at all. because of the arbitration clause. Is the arbitration clause invalid because the agreement's not in Indonesian? There's not a clear answer to this, but in that case, in Qatari Air Services, the court said, we're not interested in the arbitration clause and invalidated the agreement. It ignored Article 3 completely. That case is on kasasi now to the Mahkamah Agung. I don't know if there's been a decision yet, but it's a very complicated question. The chicken and the egg, which comes first? The invalid agreement or the arbitration clause? I'll just repeat it. Is the agreement invalid because it's in Indonesian, or is that a question the court can't decide because it's got an arbitration clause? Who knows? So that's the first two cases where the courts did apply the 2009 requirement that the agreement be in Indonesian to be valid. Now, that decision was at odds with, that is, the courts in 4 other decisions made completely different decisions. And if you feel confused, that's okay. It's very confusing and unclear. So in 4 cases, the court said they had no jurisdiction over a contract that was not in Indonesian because of the arbitration clause. So in Buksani and Vatvani, and in Chatur Jaya and Hotels Asia Pacific Limited, and PT Multispidindo Jaya, and in Ivan Krishna and Hilton Bandung, each of those decisions, and they were decisions of different courts, Central Jakarta District Court and Bandung District Court, in each of those decisions, the court said that the existence of an arbitration clause meant it had no jurisdiction over the dispute, and it couldn't even consider the language of the contract. And when the Chatur Jaya decision went on kasasi to the Mahkamah Agung, it agreed with that position, that the court couldn't even decide it, couldn't decide the issue of language because of the arbitration provision. So we have a direct contradiction between the cases, the Kokos Jiang Qatari Air Services case that invalidated the agreements, and these 4 cases where the court said can't consider it because of arbitration. But we do have, I would say there seems to be a trend of Indonesian courts refusing to hear a case under the 2009 languages and symbols laws that involve a contract not written in Indonesian if it's got an arbitration clause, on the grounds that it has to go to arbitration. We'll wait and see what happens in the Qatari Air Services case when the Supreme Court makes a decision. Okay. Sorry, just 1 minute. We have 4 more cases that need to be looked at, and it's very difficult to draw any conclusion from these 4 other cases. In the first one, which is UOB Property and PT Millennium Penata Futures in 2019, this is a very strange decision, and it's probably just hard to explain what it meant. First, in no other decision has a court used the 2 arguments that the Central Jakarta Court relied on to make its decision. The Central Jakarta Court said the 2009 Languages and Symbols Law does not apply to an agreement involving a foreign company. Well, that is just completely bizarre. The whole point of the Languages and Symbols Law is to regulate agreements with a foreign company. But the court said that agreements involving a foreign company do not have to be in Indonesian. It also said that the Language and Symbols Law cannot be used to invalidate agreement so a party can avoid its obligations under the contract. That makes no sense at all. The whole point of the 2009 Languages and Symbols Law is to make a contract void. So that's just an inexplicable and strange decision that doesn't make any sense. In the other cases, and I can't explain to you why the court made those findings. Two other cases, the Central Jakarta Court in Dendi Kurniawan and PT Kone in Indo Elevator, and the Subang District Court in Hyun International, they simply completely ignored the question of the 2009 Languages and Symbols Law. Even though the agreements, in all of these cases, the agreements were only in English and not in Indonesian. But in these two cases, these two courts just pretended the 2009 Languages and Symbols Law did not exist. And they simply did not apply the language rule. Instead, even when these cases were appealed to the high courts, they also ignored the language law and didn't even mention the language law in their judgments. That is really quite strange, because the language law was mentioned in the documents submitted by the parties. In other words, the question was raised before the courts, but they pretended it wasn't there. There's no legal basis for the courts to simply ignore a clearly applicable law without giving any reason at all. I don't know why these decisions were made the way they were, completely ignoring the law. Maybe there was some improper influence. I don't know. It's just a possibility. But there are two cases where the court has simply ignored and refused to implement the Languages and Symbols Law. The last case, Alexander Ford and Mi Lee Ford Chung, a 2019 case of the Amlapura District Court and then the High Court. The court took the exact opposite view to the court in Bangun Karya Pratami Lestari about the relationship between Article 31 of the 2009 Language Law and Articles 1320 and 1337 of the Civil Code. It simply said that if you do not comply with the language law, that does not make an agreement invalid under the Civil Code. In other words, although you have breached the law, the language law, the court said that does not mean that the agreement does not have a permitted cause. In other words, what it meant was, what the court was saying in this case was that the language law is not enforceable. I can't explain this decision. It doesn't seem to make any sense at all. Again, the reasons the court gave are, in my view, incoherent. They don't make sense. If you breach a provision of a law, then I don't see how it can be a permitted cause under the Civil Code. However, the court said you can breach that law and it doesn't have consequences. Again, as I say, the exact opposite position as was taken in the Bangun Karya Pratami Lestari case. This was a decision of the District Court, which was approved by the High Court. However, Bangun Karya Pratami Lestari is a Supreme Court decision. So I suppose most Indonesian lawyers would consider the Bangun Karya Pratama Lestari case as the more important decision. So where does this leave us? In summary, since Bangun Karya Pratama Lestari, courts in their decisions have usually followed that case and have said that a contract only in English is invalid because of language law. Generally, but not always. And in some cases, they have refused to apply it. They have not done anything really to clarify the status of foreign language contracts. In some cases, have ignored the question altogether. However, it does seem pretty clear that courts in Indonesia are likely to refuse to hear any claim to invalidate an agreement because it's only in English if the agreement has a provision, a clausule, referring any dispute under it to arbitration. The courts do not seem to want to decide disputes over contracts with an arbitration clause, even if they are only in English. So what happens when an agreement only in English goes to arbitration? Do arbitrators apply Indonesian law and invalidate that agreement under the 2009 Languages and Symbols Law. I've been doing research on this with two of my colleagues here in Australia. One of them, I think a lot of you will know, Dr. Nadir Shah Hossain, and also Associate Professor Jeremy Kingsley. And we could only find one case, an arbitration decision, where the question of the 2009 Languages and Symbols Law was dealt with. This is a 2017 case. PT Kerui Indonesia and PT Agung Glory Cargo Atama. Now, this was a case that a dispute over a contract only in English that had an arbitration clause. And this went to arbitration, not to the courts. It went to BANI, Badan Arbitrasi Nasional Indonesia. Now, in the arbitration by BANI, it was argued that the agreement was unenforceable because there was no Indonesian language version. It was only English. Now, BANI, and this is quite a surprise, BANI said, no, that's not a problem. The use of English, it said, quote, the use of English language in the agreement is not contrary to morals and does not contravene public order. I'll just repeat. It said the use of English language in the agreement was not contrary to morals and does not contravene public order. BANI completely ignored to mention that another ground for invalidity under that same provision of the Civil Code is that it has a non-permissible cause, prohibition by law. That was relevant because the agreement's clearly prohibited by law, as it was only in English, and therefore breaches the 2009 language law. The arbitrators ignored that, and they did not explain why they made their findings, and they did not explain why they totally ignored the 2009 Languages and Symbols Law, even though the parties in that dispute had raised it. It was discussed at arbitration, but BANI ignored it. This case was taken to the Supreme Court from the arbitration by BANI, but the court said that it couldn't decide it because an application to annul or to overrule an arbitral award, I'm sorry, I'll just rephrase it. The case went to the district court, and the district court decided to uphold the arbitration, then went to the Supreme Court, and the Supreme Court said the decision of the district court cannot be appealed, and so it didn't consider the problem. But this is a very, very strange decision because, again, like some of the other courts that I've mentioned, BANI, arbitral body, totally ignored the 2009 law, even though it was raised before it. Why did it do that? I don't know. So, the bureaucratic interventions, by which I mean new laws that were passed, the Surat Edaran, the presidential regulation, and so on, have created a lot of uncertainty about how to interpret Article 31 of 2009 language law. But it seems pretty clear that you can have multiple versions and you can choose the dominant version. However, the court approach, what the courts have done with Article 31 is completely incoherent. It's just not clear from the courts whether, even if Article 31 is even enforceable at all, because often they've totally ignored it. What does this all mean for practice? Sorry, excuse me. Sorry about my slides. So let me just talk a little bit about what this means for lawyers who are drafting agreements. Most businesses involved in major business transactions in Indonesia want clarity and certainty. And so generally speaking, Indonesian lawyers try to comply with the Indonesian language requirement in Article 31 of the 2009 Languages and Symbols Law. And they do this often by drafting documents bilingually in 2 languages. And they also try to include a clause in the agreement that says that Indonesian is the dominant language or the language to be used if there is a dispute, the preferred language, or the so-called trumping language provision. It's a word sometimes used. This is the cautious approach taken by most major Indonesian law firms who take the view that doing anything else would not be good practice. It would be imprudent. Likewise, many major commercial contracts, business contracts, also often include arbitration clauses, and they usually exclude the courts, including as regards the 2009 Languages and Symbols Law. So because they contain arbitral clauses, then the courts have no say in it. That's usually the case. It's not clear what happens, what arbitral tribunals, arbitrators would do when a contract that is not in Indonesian comes before them. The only example we've got, they ignored that question. So therefore, the best solution is to always draft contracts involving a foreigner in 2 languages, and to always include a provision that states that Indonesian is the dominant version, and always, sorry, I'll just stop there. You may also want to put an arbitration clause in as well. But that's not a full solution because we don't know what arbitrators do. However, bilingual drafting is not a complete solution. It has its own problems. The most obvious is that it adds costs to business transactions, and these can be a lot if parties have to hire their own translators to review the versions drafted by the other party. A lot of business contracts take 3, 4, 5, 6, 7, maybe even 20 versions for big contracts, and you would have to use translators at each of those stages. It gets very expensive. Experienced and reliable translators who are expert in Indonesia's legal system and also the relevant foreign legal system are very rare in Indonesia. There are not many people who understand legal language in 2 languages and also understand something about the legal systems, and they can be very expensive. So for a lot of businesses, it's not feasible. Even with a skilled translator assisting, being clear and precise can be difficult if negotiations have taken place in different languages and then are translated into Indonesian or the other way around. This is because there are big differences between Indonesian and English, especially in legal terminology. I'll give you one example. The word equity. Equity is often taken to mean a share in a business, saham. But in English, it also means keseimbangan, or a balance. But in English, it also means a system of law, a whole series of principles that operate alongside written law to moderate the application of written law. So it means 3 quite different things. And that's just one simple word, equity. So important meanings can be lost in translations where words have similar but not identical meaning, and where complex concepts are simplified, distorted by translation into a different grammatical structure. And I say this because this causes me a lot of difficulty myself working between 2 languages. And so it means that unless you use a highly skilled expert interpreter, the likelihood of errors in contract translation between English and Indonesian is really quite high. And it can actually create more new problems in the course of creating these agreements. Okay. Another example of this is that in English tradition, Anglo-Saxon tradition contract law, you cannot have a contract unless there is what is called consideration. Consideration means that as well as all the elements of a contract in the Indonesian system, you also have to have a 2-way exchange between the parties. Each party must receive some benefit from the contract. You cannot have a purely 1-way agreement where somebody agrees to do something for someone else without something else in exchange for coming back. This is a very general description of what's called consideration. If you don't have consideration, there is no valid contract. Now, that is a concept that does not exist in Indonesian law, but it's very important in Anglo-Saxon common law. And the word for it is consideration. There is no Indonesian term for consideration because you don't have it. So how do you translate that? If someone can tell me, I'd be really happy, because I don't know. That's just a few examples of the problem. So what are we going to do? What are the solutions to this problem? There are two possible reforms Indonesian lawmakers could introduce to resolve the problems I've been talking about and create certainty about the rules governing language of Indonesian contracts. It's basically by amending the 2009 Languages and Symbols Law and the 2004 Notaries Law. It has to be done at that level by the DPR, because if you just create another regulation or a surat edaran or a ministerial keputusan or whatever it is, you're just going to make the situation even worse. So it has to be done through amendment of the undang-undang. The first option is to take away the flexibility and make it absolutely clear that all commercial agreements involving Indonesians must be in Indonesian language, full stop. A contract or deed can be in two versions, but only the Indonesian language would be enforceable in court. And that would be very clear. And it would mean that you can have multiple versions, which the other party, the non-Indonesian party, can use for reference and to help it understand, but only the Indonesian language is valid. That would create certainty about the rules, but it would still leave the foreign investors with the problem of getting translations of the Indonesian languages that are accurate. And they can't be sure of that. The second approach is, so the first approach is remove the flexibility. The second approach is to do the exact opposite and to create maximum flexibility by making it clear that choice of language clauses are enforceable in Indonesian courts, and give the parties to a contract complete freedom to choose whatever language they want for their contract. And then the courts would enforce that. That would still create a problem for the courts, of course, because if the parties could do that and they chose a French, or let's say a Spanish contract, how is an Indonesian court going to interpret and understand a Spanish language contract? Again, they'd still have to have translations. They probably have to have translations provided by the two sides. They'd probably disagree. So none of these solutions really solves all the problems. There's still the task of managing legal translation, but either of those choices will be better than the current situation, which is, quite frankly, agak kacau. If neither of these reforms are taken, lawyers handling transnational transactions in Indonesia just have to keep drafting bilingually, but will have to keep advising their clients very carefully that, first of all, they can choose two versions, but the Indonesian courts might only recognize the Bahasa Indonesia version, even though the law allows them to choose their version. The courts might not recognize that. So they should do this to be prudent, but they need to warn their foreign clients that there may still be problems because the courts have been inconsistent. If nothing is done, the problems of added expense and complexity in the uncertainty agreements will continue in Indonesia, and that will not help Indonesia in attracting foreign investment. Indonesia needs foreign capital to support economic growth and service its infrastructure needs. So this is not an abstract question of drafting contracts. It actually goes to the big problem Indonesia has of attracting more foreign investment. Thank you very much for your patience today.
Thank you, Professional Team. Dan berikutnya kami mempersilakan kepada bapak-bapak dan ibu-ibu peserta webinar hari ini, kalau ada yang ingin didiskusikan dengan Pak Chandra dengan Professional Team, kami persilakan untuk tanya jawab. Kita langsung open diskusi ya. Boleh dengan simbol angkat tangan atau dengan lewat chat. Silakan bapak-bapak dan ibu-ibu. Ya, dipersilakan bapak-bapak dan ibu-ibu jika ada yang ingin ditanyakan. Bagaimana? Apakah ada yang ingin ditanyakan Bapak-bapak dan Ibu-ibu?
Sama aku yang tanya ya.
Baik, Pak.
Ya. Tim, no one asks you, so I will ask you.
Berani.
I'm interested in anatomy of a contract of in common law system. They come from precedent, right? Precedent like a judgment law, like they don't, like Indonesia has a civil code. The contract rely on like a 1338 civil law that like a pacta sunt servanda. Yeah, they pour into the civil code, but it is always increase, right? The element of the contract in common law system is according to, the the concrete peristiwanya, concrete of event, right? Even the case. So like offer and acceptance, and then consideration, and then intention, legal relation, lapse of time. Yeah, it comes from the decision of the judge. It comes from the judge with the precedent. So so what do you think about I'm interested in consideration, because this is when we agree on something, we consider, right? We consider that I want this. If I buy, suppose I buy whole computer with the model and the number of the model. So, or the color, suppose the color, I consider black, and then later they send me not really in black, but a little white, you know. Can I reject that contract because of it's not the same that you offer, suppose like that? Can I, or you just accept, but all the model is the number model, and only the color is different. Can you reject for that?
Thank you. That's a good question, Chandra. The question would be the terms of the contract. In other words, when you entered into the contract, did you specify the color?
Yeah.
So if you said, I want a green computer, I want this model, this with this capacity, this ability, these applications, blah, 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 and it must be green. If they then send you a yellow one, that's just a simple breach of contract. They have failed to perform the contract in accordance with the terms. And so you would give them a chance to remedy their non-performance and provide you with a green one. If they fail, then you can terminate it simply because they have not performed the contract in accordance with the terms. If you didn't specify the color, you just said, I want that model computer, then it's not a term of the contract. And so you have to accept whatever color they give you because you didn't require it to be any one particular one. So that's not really a question of consideration. Consideration goes to the formation, the making of the contract. And it goes to an old principle which says that a contract is a bargain. And a bargain has exchange. And there has to be something going in both directions, not just one direction. And if you don't have something going in both directions, then you have no bargain. It's just a gift. And so it's not enforceable as a contract. And it was called consideration. It's a linguistic, an old linguistic term. It's like a lot of English law terms. They don't really mean anything. It's just an old word that was used in the past. Consideration does not have to be of the same value as the thing that is being exchanged. It can be anything at all. It could be, I could pay you $1 for your house, as long as there is something being exchanged. Your house might be worth $100,000, and I just give you $1. If you agree to that, then that's consideration. But if you just give me your house with nothing coming back, then you can't enforce it as a contract. And that is an absolutely fundamental requirement for a contract in Anglo-Saxon common law system. And so a lot of an Anglo-Saxon common law contract will always say, I agree to give you this in consideration of you giving me that. And Anglo-Saxon system lawyers are very, very concerned to make sure that is clear, to avoid a claim that the contract's invalid for lack of consideration.
Yeah, it is also mean the benefit of each party, right? The benefit of the contract, because even I have a $10, they have a $100 value is fine, because I have a consideration, right?
Yeah.
This is like that.
Yeah, it doesn't have to be full consideration. It could be symbolic consideration, as long as it's there.
Okay.
Mm.
Yeah, thank you.
Thank you.
Thank you very much, Profesor Tim. Dan kita,
Ini
oh ya,
ada
dari
pertanyaan.
peserta ada Ibu Riri Mela, angkat tangan ya. Silakan Ibu bertanya.
Terima kasih ya Pak.
Yeah.
Pak Chandra, selamat pagi. Prof Tim, how are you?
I'm good, thank you.
Yeah,
And you?
Prof Tim, I want to ask your opinion, because I have in hand now like one contract in English, but it states that all parties already agreed that and read carefully that this contract will be executed in English. But they stated here that they acknowledge the law number year 2009, and they agreed to waive if any differentiation between them. One day they will be execute the Indonesian language. So what do you think about this clause? Is it okay to be put in the contract, or it will be lawfully wrong?
I think that is, I know that sort of clause. I think there's a big problem with it. And that is because of this. What happens if the dispute comes later and they decide to then make a translation into Indonesian? So there is an Indonesian language version, and they don't agree on the translation. That would mean,
so means double dispute then.
That's right. And so you cannot then create the Indonesian version because they don't agree on it. And that is very likely to happen if there is a dispute, because it's quite likely that a dispute could arise from a misunderstanding about the clauses, and they will disagree on the interpretation. I've seen that a lot, that when you come to create a later translation, it's impossible for the parties to agree. And in that situation, you run the risk there is no contract. It's never been formed, because as the matter stands now, that contract in English is not valid. You must have an Indonesian language version. You can choose which one of those two versions is to prevail in a dispute, and you can hope the court agrees. You could do that under the presidential regulation, but you must have at least an Indonesian version at the start. So if you don't have it, the contract's not valid under the 2009 law.
Yeah, because sometimes we in a rush for the executed the project, then
Yeah. Well,
the template is in English, and then we put that clause to avoid
yeah, it's very
our
dangerous.
yeah.
Very dangerous. It's better to try and find a very good interpreter.
Because we're chasing the target.
I know. I understand the problem. It's
Yeah,
contract drafting is a mimpi buruk.
yeah.
A lot of the time.
Unfortunately.
But
Okay.
you really, if you only have one version,
Yeah.
look at the Indonesian one. But
It's better in Indonesia.
better not to agree to translate later, because it's very hard to get everyone to agree once a dispute starts.
Okay then. Thank you, Prof.
Thank you, Ms. Riri Mela. And
There's
there is a question from Mr. EKN for Professional Team. If we have to go on with contract and choose alternative dispute resolution with arbitrate, then the result only has a faultful compliance with court enforcement. Could it be
Could this be another reason of withdrawal with one of the parties? I'm not quite sure I understand the question. If you go to arbitration, then you can later enforce the arbitral award through the courts. That's okay. The thing about an arbitration is that, in principle, once you have an arbitration clause, the district court, Pengadilan Negeri, has no jurisdiction anymore. And so an agreement with an arbitration clause has to go to arbitration. That doesn't stop it being enforced later by a court once you have the arbitral award. The problem is that when the language provision has come up in arbitration, the only time I've been able to find it has been considered in arbitration, they just completely ignored that issue. They completely ignored the language law. So all I can say is that the courts won't look at the contract, generally speaking, if it has an arbitration clause, but also say that arbitrators, the one example I've seen, the arbitrator didn't apply the language law. I don't know if you think that's good or bad, but that's about all I can say.
Okay, thank you Professional Team and thank you Mr. Eka. Apakah penjelasan dari Professional Team sudah jelas buat Mas Eka? Baik, saya kira sudah jelas. Mungkin dari teman-teman ada lagi yang mau ditanyakan dari bapak-bapak dan ibu-ibu kalian?
Oke.
Baik, mungkin dari bapak-bapak dan ibu-ibu sudah cukup ya barangkali ya pertanyaannya. Untuk itu sekarang kita masuk ke closing statement dari Pak Chandra dan Profesor Tim Lindsey. Kami persilakan ke Pak Chandra untuk memberikan closing statement.
Okay. I speak in Indonesia ya. Terima kasih Prof Tim dan terima kasih mahasiswa saya ataupun peserta lainnya atas kedatangannya ya. Jadi intinya yang saya mau sampaikan adalah tidak mungkin membuat terjemahan yang akurat ya di dalam dua bahasa ini, dua bahasa Inggris dan bahasa Indonesia, karena mereka memiliki bisa dilihat dari sudut pandang konsep berbeda. Ya, kemudian juga dari bahasa pun juga terjemahannya akan bisa memiliki bias-biasnya. Ya. Jadi dari konsep bisa diterima dan tidaknya ya. Jadi sebenarnya kita harus bisa memperbaiki lagi nih. Artinya kita mesti bisa menerima Inggris sebagai bahasa di dalam court ya, di dalam litigasi kita supaya bisa mereka menerima kalau ada perselisihan tidak hanya arbitrase tok, ya, tetapi di dalam litigasi pun juga harus bisa dilakukan karena tidak harus selalu dengan arbitration, ya. Dengan litigasi pun juga seharusnya bisa, tetapi tentu bahasa yang jadi masalah, ya. Jadi saya pikir dengan sebagai alat bukti bahasa Inggris pun seharusnya bisa digunakan di dalam pengadilan. Demikian dari saya, ya. Terima kasih. Tim, what is your
My advice to notaries is always have a version in Bahasa Indonesia, because it's safer if you have one. If you want to have another language, that's good. Tapi paling sedikit dalam Bahasa Indonesia. Boleh ditambah dengan versi dalam bahasa lain, but you must have an Indonesian language version first, as the minimum requirement to be safe with your clients. That's my advice to you, because the situation in the courts is very unclear. So you have to take the safest, jalan yang paling aman, yaitu paling sedikit versi bahasa Indonesia. Boleh ditambah dengan versi lain. Kalau mau, kalau klien ada uang yang cukup, kalau ada penerjemah yang sangat-sangat pintar dan berpengalaman, oke, boleh dalam bahasa lain, tapi paling sedikit bahasa Indonesia. Itu sudah cukup dari saya di negara kanguru. Dan
Baik.
sekali lagi saya mau mengucapkan terima kasih yang sedalam-dalamnya atas kesempatan ini, dan I wish you all success, dan khususnya terima kasih pada Prof. Chandra.
Thank you very
Terima
much,
kasih,
Professional
Tim.
Team. Your Indonesian is very good.
Masih dalam proses.
Baik. Untuk itu dengan demikian kami ucapkan terima kasih kepada Bapak Chandra dan Profesor Tim atas closing statement yang telah disampaikan. Dengan demikian maka ya baik Pak, dengan pembacaan doa kita tutup dengan pembacaan doa dari baik, saya rasa saya harus baca doa ya. Baik, saya baca doa. Bismillahirrahmanirrahim. Ya Allah, berikan karunia, rezeki, dan ilmu yang luas atas acara yang telah kami selenggarakan pada hari ini. Semoga Engkau berikan ilmu yang bermanfaat bagi kami semua. Semoga kami bisa mendapatkan pelajaran-pelajaran yang terbaik dari pemaparan dari seluruh materi yang telah disampaikan oleh Profesor Chandra dan Profesor Tim. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzabannar wa sallallahu ala sayyidina Muhammad wa ala alihi wa sahbihi wa sallim. Dengan demikian acara hari ini kami tutup. Kami mohon maaf apabila ada kekurangan-kekurangan dalam penyampaian. Semoga
foto bareng Rama.
Bagaimana Pak?
Foto bareng.
Oh ya baik Pak. Sebelum kita akhiri kita foto bareng dulu ya kepada bapak-bapak dan ibu-ibu semuanya supaya on cam kamera kita foto bareng. Ya baik, untuk yang belum on cam mohon on cam. Baik, baik, kita langsung mulai foto-foto dulu ya. 1, 2, 3. Baik, sekali lagi